Okay, are we live? Okay, I think we are. Let me double check, make sure we have everyone in the waiting room. Okay. Well, good evening, everybody, and welcome to the Citizens Law School. We are delighted tonight to have Amy Hall with us to talk about landlord-tenant law. And Amy is an attorney with Montana Legal Services Association. That is a statewide nonprofit law firm that represents those who can't afford to hire an attorney in civil law matters. Amy has been with the Helena office of MLSA since 2002, and since 2006, she has focused on representing tenants statewide. Tonight, if you have any questions, you can go ahead and enter them into the chat. And when you do, I will be monitoring the chat. And once we have a few questions pile up at appropriate times, I'll stop and I'll tell Amy we have questions in the chat and she can address them. And then at about 45 minutes in, we'll pause. And if anyone else has further questions, we'll have a little Q&A at the end. So with that, I will turn the program over to Amy and welcome.
All right. Thank you so much, Brenda. And thanks to all of you who are spending your Wednesday evening with me for the next hour. What we will cover today is some basics about landlord-tenant law in Montana, including evictions, discrimination, requests for accommodations, how to request repairs, security deposits. So we got a lot of topics to cover and we'll kind of breeze through. But like Brenda said, please do submit your questions in the chat box and we'll get to those as they come up. Okay, so we're going to be talking briefly about 3 different statutes in Montana that apply to landlord-tenant law or landlord-tenant relationships. The first is the most commonly applied in Montana. It's called the Montana Residential Landlord and Tenant Act of 1977. It applies to any tenant who rents an apartment, a house, or who rents both the mobile home and the lot. So that's one landlord-tenant act. The second one is the Residential Mobile Home Lot Rental Act. This applies to folks who own their own mobile homes and are only renting the lot or the land that their home sits on. The statutes are a little different between those 2 acts. The most significant differences for the mobile home lot renters is that a landlord must have good cause to terminate the lease of a mobile homeowner. And the reason for that is because it takes a lot of money, right, to move your big mobile home off the lot that you're renting from the landlord. And so for that reason, the law says that landlords cannot terminate a mobile home lot renter for no cause, even if their tenancy is month to month. So if your tenancy is month to month and you're renting an apartment, then the landlord doesn't have to have any reason to evict you. They can just give you a 30-day notice telling you have to move for no reason, but not so if you're a mobile home owner only renting the lot. The other significant change is that with a mobile home lot rental, the tenant is entitled to 7 days notice if they're behind on rent. So the landlord has to give you 7 days to pay the rent that's due or vacate. And if you're not owning your own mobile home and you're renting an apartment or a house, you are only entitled to 3 days notice to pay the rent or vacate. Okay, then the third law that we'll talk about today is the Residential Tenants Security Deposit Acts that applies to the security deposits paid by any tenants, whether they are mobile home owners and are paying a security deposit for the lot only, or whether they're the regular renters. Okay, so what are a landlord's responsibilities? And these next slides apply under the Residential Landlord Tenant Act, not the Mobile Home Lot Rental Act. But basically, the landlord has to keep the rental in good and safe order, keep all common areas clean and safe, make repairs to the premises that are necessary to keep the premises fit and habitable. They also have to inform the tenant who's in charge of the rental and provide smoke detectors and ensure they're in working order. Then the tenant also has responsibilities. The tenant has to pay rent and utilities as agreed, has to comply with city, county, and state regulations applying to their tenancy, has to keep their rental clean and sanitary, and dispose of garbage and waste, and properly operate any systems provided by the landlord in the rental, and maintain the smoke detectors, including battery replacement when the smoke detectors are provided by the landlord. And of course, the tenant cannot damage or destroy any part of the rental property. So if you're a tenant, what do you do if there are issues with your landlord? And if you're a landlord, what do you do if you have issues with your tenant? The most important takeaway from this entire hour's presentation is to try to keep the lines of communication open. So if you get a notice from your landlord, contact the landlord and say, hey, I saw that you're saying that I have too many people staying here. I want you to know those people are gone now. They were only here for a day or whatever it is, but communicate with your landlord. And the same thing goes for landlords. What I do every day is represent tenants in landlord tenant disputes. And often I hear from tenants that they are frustrated with their landlord because the landlord didn't call them or contact them in any way before they sent them a notice saying, you've got to move because you have too many people, for an example, in your apartment. So if we could just try to keep the lines of communication open between landlords and tenants, I think that would help resolve a lot of problems because nobody wants to end up in court over these landlord tenant disputes. It's a huge emotional drain and it costs money for both parties. So if possible, it's better to try to resolve those disputes without any kind of court action. So for tenants who are behind on the rent, my suggestion is always call 211 from your phone, or if you prefer an online search, go to 211.org to see if there are any local agencies that can help you get the rent paid. Probably some of you know there was a program in Montana called the Montana Emergency Rental Assistance that was great at helping renters get caught up on rent. Unfortunately, those funds have all been spent, so that program no longer exists, but there are other programs in all of our communities. So please reach out to 211 if you need help paying your rent. And always, whether you're a landlord or a tenant, it's good to document whatever communications you have with follow-up text messages, emails, or letters to the other party. Okay, so let's talk a bit about evictions. What are the stages that a landlord must go through if they want to evict a renter in one of their rental properties? So the first step is the landlord has to give the renter a notice to vacate. That notice can be by letter, text, or email. Okay, it doesn't have to come by certified mail. It doesn't have to be served by a process server. This is just the initial letter where the landlord says, in the example I used earlier, you have to move out because you have too many people living there, and that's a violation of your lease. So the landlord gives that notice to the renter. Then in that letter, the landlord also has to give the deadline by when the renter has to vacate. So the letter will say, you've got too many people living there, you have 3 days, for example. Could give 14 days or 30 days, but the landlord has to specify the number of days the tenant has to remedy the situation or to move out. And if the tenant ignores the letter and doesn't do anything or doesn't fully comply with the notice by getting rid of the people or fixing the issue, then the only thing the landlord can legally do if they want to evict the renter is file an eviction lawsuit against the renter in court. Okay, so the landlord cannot shut off the utilities for the renter or change the locks on the rental property. The only thing the landlord can do if the renter doesn't comply with whatever the landlord said in the notice is take the next step, which is filing a lawsuit in court. And why do we require that in Montana and all other states in our country? The reason is because renters have constitutional rights and they cannot be removed from their rental premises without first having notice of what they did wrong and a meaningful opportunity to respond to those violations. So all of us have constitutional rights to notice and the opportunity to respond if anybody wants to take a right or a property interest away from us. So that's why the landlord can't just throw you in jail or lock you out of the rental if you don't pay rent, for example. The only thing they can do is file in court against you. Then, if they file a lawsuit, if the landlord files in court against the tenant, the next step is the landlord has to get the tenant served with those court papers. And all that means is a process server comes to the tenant in person, either at wherever they can be found. Usually it's at home, but it could be at your workplace or wherever you hang out at the park, any place the process server can find you, they can hand you a copy of the lawsuit papers that the landlord filed. Those papers will say right on them, you have 5 days to file a written answer from the date you were served. So 5 days is not a lot of time there. So it's really important if you're the tenant and you get served with eviction court papers, be sure to get your answer filed with the court within 5 business days. Usually the court papers won't tell you it's actually business days. It'll just say you got to file within 5 days. But we know from the local court rules that it's actually 5 business days after you get served. So in counting those 5 business days, you do not count Saturdays, Sundays, or court holidays. So like Veterans Day, which just happened yesterday, that would not be counted in those 5 days that you have to file your answer. So let's say I get served as a renter today with court papers for eviction. Today's Wednesday. I have Thursday, Friday, then we skip Saturday and Sunday, and then Monday, Tuesday, and Wednesday. My answer, written answer, would have to be filed with the court where the lawsuit is filed by Wednesday of next week. Okay, then after I file my answer as the tenant, the next step is there is a hearing held by the judge. So this is important for tenants to recognize because what this means is because there's a hearing held, that means it's the judge who's going to make the decision for whether or not you're in violation of your lease and you are evicted. It's never just up to the landlord to make that decision. The landlord may think you violated the lease by having too many people staying with you, but if they cannot prove that at the hearing, where you show up and raise all your defenses with the court, then the judge will rule in the tenant's favor and the tenant will get to stay. So if the landlord takes the renter to court, the landlord has the burden to prove whatever the grounds are for eviction, whether it's a violation of the lease or if you're a month-to-month renter and the landlord just gave you a 30-day notice to vacate for no reason. The landlord has to prove whatever their grounds are, whatever they said in the lawsuit papers for the eviction. Then after the hearing, if the landlord wins in court, the court will enter a judgment, which is a piece of paper signed by the judge saying the landlord wins, and will set a date for when the tenant has to vacate the rental. Usually that date is pretty quick after the hearing. So it could say renter must vacate immediately. It could say 5 days. The judge has a little bit of leeway in deciding what day the renter has to move out. But if the tenant doesn't move out by the deadline given in the judge's order, then they can be physically removed from the rental, which means that a sheriff comes to execute on a writ. The writ, WRIT, is a separate court order that landlords can get, which is addressed to or directed to the sheriff's office, telling the sheriff, it's signed by the judge or the clerk of court, telling the sheriff's office to please go and forcibly remove the tenant and their family members from the rental because they have failed to vacate by the deadline the judge gave them in the court order.
Okay, Amy, I'm going to stop for a moment. And we just have a couple of comments in the chat.
Okay.
One is more of a comment than a question, but I think there is also kind of curious about the rights of the landlords in this. And then the other question is related to if there's an actual violation of constitutional rights. And so I think those are just two questions that are kind of popped into the chat that perhaps you could address.
Okay.
So first question was just what are some of the landlord rights in this, and then the other is whether it's a tort claim is a good idea if there's a constitutional right being violated.
Sure. Okay. So I'm looking at the chat now. And yes, my apologies if my presentation has seemed really slanted toward the renter. That's because I've been a renter's advocate for, 30 years now. So my apologies. Absolutely, landlords have rights too. And I'll try to present both sides. Definitely, these slides are education for both parties. I'm not intending to slant toward the renter in any way, but keep me honest on that because that is certainly not my intent. And landlords do have rights in this eviction process as well. Um, the main benefit to the landlord in filing the eviction court action is because if they prevail in court, they can end up taking back possession of the rental. So that's a huge benefit, and also can get a money judgment against any tenants who haven't paid the rent or owe other money to the landlord. Then the next question is, are torts a good idea when constitutional rights are truly violated? I'm not sure. You may be asking if either party would have the right to file a lawsuit against the other party if they feel like their constitutional rights are violated. And the answer to that is yes. That's beyond the scope of this presentation. But yes, if the landlord or the tenant feel like their constitutional rights have been violated somehow in the landlord-tenant relationship, they certainly can talk to an attorney about pursuing those claims. Okay, then back to the slides. This slide covers the difference between termination and eviction. So the landlord starts the process, like we talked about. If they want to try to terminate the tenancy of their renter, they start by issuing a letter to vacate. That letter must be in writing or by email or text message to the tenant. Provide the number of days that the tenant has to vacate, and that number of days depends on the reason for termination, which we'll get to in just a minute. The letter also must state the reason for the termination, and if the tenant doesn't vacate by the deadline in the notice, then the landlord files the court action. Eviction is a term that refers to being physically removed from a rental. And as we've talked about, a landlord can only legally evict a tenant through a court action where the tenant has the right to file an answer and appear in court. the landlord cannot force a tenant out by changing the locks or shutting off utilities unless they've already gotten an order from the court to do that. Okay, then this provides some of the number of days. You know, the number of days a tenant gets to vacate depends on the kind of violation it is. So you can see that if they're a month-to-month renter, they are entitled to a 30-day advance written notice to vacate if they're being asked to leave for no reason, just because they're on a month-to-month tenancy and the landlord doesn't have to have a reason. Or if they're a week-to-week renter, if they pay their rent every week instead of every month, then they're entitled to a 7-day notice to vacate. And again, the landlord does not have to give a reason. But if they're being asked to leave for some kind of a reason, we call that for cause. The landlord has cause for asking the tenant to move. The number of days varies. So for non-payment of rent, and again, we're still talking about non-mobile home lot rental rental agreements. So for non-payment of rent, the tenant gets 3 days notice. For a repeat violation that happens within 6 months, that's 5 days if the landlord's already given notice for the previous violation, and this is the repeat violation. If the tenant's creating a reasonable potential of damage to the premises or injury to neighbors, that's 3 days. Unauthorized pet or person, 3 days. Damage to the rental is 3 days. Or any other non-compliance or violation that's not otherwise specified in Montana law, that's a 14-day notice. And some of the violations, like non-payment of rent, for instance, can be remedied by the tenant. So if a tenant gets a notice saying you're behind $300 in rent, you got to pay in 3 days or move out. If the tenant pays that amount within the 3 days, then the tenancy does not terminate and they won't be facing an eviction court proceeding. They just get to stay because they remedied the rent situation. Okay, so this is a slide that shows what the remedies and risks are of going to court. And there are remedies and risks to both parties. Like I said earlier, the best result for landlords and tenants are to try to communicate with each other and resolve the differences without ending up in court. But if there's a court action filed, then these are the remedies and risks. So for the landlord, the benefits that they can achieve by going to court are the writ of assistance to remove the tenant from the premises, a judgment for any money owed, injunctive relief. For instance, the judge can order the tenant to do something, such as ordering the tenant to allow the landlord access to the premises if the tenant has been refusing that access. The landlord can also possibly recover up to 3 times the rent or triple the amount of the landlord's out-of-pocket costs if the tenant's holdover is purposeful and not in good faith. That's language from the actual law. And if the landlord prevails in court, the landlord can ask the judge to order the tenant to pay their attorney's fees and court costs. And you see on the tenant's side of this slide that if the tenant prevails in court, the tenant can ask the judge to order the landlord to pay their attorney's fees and court costs if they hired an attorney. So that decision about whether to award attorney's fees is discretionary with the judge. The judge does not have to order the loser to pay the winner's attorney's fees, but it is within the judge's power to make that decision and to do so. Okay, so the remedies and risks to the tenant of going to court are if they win at the hearing, they will get to stay in their rental. They can maintain possession of their rental unit. If they file a counterclaim against a landlord, for instance, if the landlord hasn't provided heat in the winter, and that's a violation of the rental agreement, and it's a violation of Montana law, and the judge awards money compensation to the tenant for that violation, then that would be a benefit to the tenant. The tenant can also get the ability to terminate the rental agreement if the landlord is in violation. So, if the landlord has, for instance, not provided heat in the winter and the tenant just wants to terminate their lease, maybe they're in their third month of a 6-month lease and they want to be able to move out early, they can get that remedy from the judge if the judge agrees with them on that. And the tenant can also recover up to 3 times the rent or 3 times their actual damages that they suffered for the landlord's unlawful ouster, which is the phrasing in the law, which says if the landlord unlawfully excludes them from the premises by shutting off utilities or locking them out of the premises without first taking them to court, they can recover up to 3 times the amount of rent or their triple damages for that. Or if the landlord retaliates against the tenant by filing an eviction lawsuit against them for one of the 3 protected reasons in the retaliation statute. And those three reasons are complaining, if the tenant has complained to the landlord of repairs that are needed for health and safety reasons, or has complained to a government office like the fire marshal about the landlord's failure to provide a safe rental, or if the tenant has joined a union or participated in a tenant union or similar organization. Those are the 3 activities that could trigger a judge to find that the landlord has retaliated against the tenant by filing an eviction lawsuit against them. If the tenant has done one of those 3 things within 6 months of when the landlord took that action against the tenant. Okay, just a couple of slides about discriminatory actions in housing. So under the Fair Housing Act, which applies to most housing providers in Montana, it's illegal for someone to discriminate in any aspect of the housing industry. So whether they're a real estate agent or a landlord, they cannot discriminate based on someone's race, color, national origin, religion, sex, family status, such as having children under 18, or pregnancy, or disability. Additionally, in Montana, we are protected from discrimination based on marital status, age, and creed. So what are some examples of actions that could be considered discrimination in housing? If someone is denied a service or denied a rental because of one of these protected reasons that are on the left side of the page, so because of their race, color, national origin, if any of those reasons are the reasons that they were refused a rental, that could be illegal discrimination. Advertising. So all of the housing providers' actions have to comply with the fair housing laws in our country. So tenants, renters are protected by these anti-discrimination laws. Just a note about assistance animals. Probably folks are familiar with the fact that if someone has a disability and they're applying to rent a place, even if the landlord has a no pets rule, if they're covered by the fair housing laws, which applies to most landlords in Montana, except for very small operators, landlords who own only a few rental units, but most landlords are covered by the fair housing laws. So even if a rental has a no pets rule, the landlord may have to allow the animal of a rental whose animal is related to their disability. So those kinds of animals where the animal is related to a person's disability are called assistance animals in the phrasing that HUD uses. And if the animal is an assistance animal, then a landlord cannot legally charge the tenant a pet deposit or pet rent. You know, some landlords charge a monthly pet rent for someone who has an animal, but a tenant with an assistance animal, because of their disability, cannot be charged a pet deposit or pet rent. And the reason for that is because the animal is not a pet, right? If it's an assistance animal related to the disability, they're not pets. They are assistance animals that are considered um, exempt from any kind of pet deposit or pet rent. So to get approval from a landlord for an assistance animal, first the tenant has to submit a request for accommodation to the landlord. And until the landlord approves the request for the animal, the renter should not have the animal at the rental. So if you are needing a form to request approval for an assistance animal, I provide the link to where you can find that form online. It's a simple one-page form. And then there are also links to where you can get more information about assistance animals and to the Montana statute that covers assistance animals. Are there more questions in the chat? Brenda, I saw you pop on.
No, I think we're good. I just had a technical glitch from my end. I think that you've covered it. And I was just going to ask about verifying animals, the definition of an assistant of an assistance animal, if they have to have any kind of certification or anything.
Okay. Yep, that's a really good question. So the term that HUD uses for assistance animal, it's like an umbrella term that covers two different kinds of animals. One is an emotional support animal, which those kinds of animals don't have to have any kind of training. They don't have to have special training at all. Um, so there's no special certification that an animal has been trained as an emotional support animal, because that certification is not required. The second kind of animal that falls under the umbrella of assistance animal are service animals. And those are animals like seeing eye dogs for someone who has a vision impairment. If they use a seeing eye dog, those dogs do have to be specially trained. And so those are a separate category within assistance animals. So when a tenant submits a request to their landlord for an accommodation of their disability by approving of their assistance animal, if that animal is an emotional support animal, the tenant must provide the landlord two very specific things. One is a written verification from a mental health care practitioner licensed in Montana who has personal knowledge of the tenant's disability and has been treating the tenant for 30 days at least. Okay, so if you just moved to Montana as a tenant, you probably are not going to get your animal approved by the landlord unless you've been here for 30 days and you already have a Montana licensed provider who can verify that you're a person with disabilities and that your disability is such that you need this animal to provide you with emotional support. For each animal, the tenant must also provide proof of compliance with state and local licensing and vaccination requirements. So the landlord can still require the tenant to show that their animal has been vaccinated and that they've been licensed. If the city requires a license for the animal, the tenant has to provide that license as well. Okay, now we're moving away from disability discrimination and assistance animals to another part of the eviction process that sometimes comes up after a judgment is entered. So let's say landlord filed an eviction case against the tenant And let's just say the tenant won in court after the hearing. The judge entered a decision saying that the tenant gets to stay, and that's the final decision by the court. Let's say that the landlord disagrees with that decision for one of these reasons. If the landlord can show that the court's decision was mistaken or in error due to a mistake, inadvertence, surprise, or excusable neglect, then the landlord can file a motion for relief from the judgment that said the tenant gets to stay. And this also applies to tenants too, who lost an eviction court and think there's something that's wrong with the judgment against them. Either party can file a motion for relief from judgment, asking the court to undo whatever judgment was entered based on mistake, inadvertent, surprise, or excusable neglect. And there is a form on the website, which is montanalawhelp.org. That is a form intended for tenants to use if they want to try to undo a judgment against them. They have to, whether it's a landlord or tenant trying to undo the judgment, they have to show that they have a good reason based on one of these 4 items. The judge is not going to undo a judgment unless there's good cause to do so. So whoever is filing the motion has to show good cause for why the judgment is in error. And once the party files the motion with the court, then the court rules require that the judge set that motion for hearing within 10 days. And the parties would be notified of when that hearing is. Both parties could show up at that hearing and argue for why they think the judgment was right and should be left in place, or why they think the judgment was wrong and should be undone. Okay, another thing that comes up often is how to request repairs. So Montana law requires landlords to fix issues that affect health and safety. And the law also requires a tenant to make that request in writing to the landlord. There is a form online that tenants can use to make that request. And the law requires landlords to make those repairs within 14 days if the repair is a non-emergency condition, or 3 business days if it's an emergency. And if those repairs are not timely made, then the tenant does have the option to file suit against the landlord to ask the judge to force the landlord to make those repairs that affect health and safety. Okay, these 2 laws I wanted to bring up to everyone's attention because they were just recently passed by the legislature in the session that ended in the spring of this year. So both of these laws apply to fees that are sometimes charged to tenants. So if a tenant has had to pay an application fee to apply for a rental after October 1st of this year, and that landlord manages at least 4 rental units, the tenant may be entitled to a refund of their application fee if they didn't get the place. So this new law requires the landlord to refund the fee to the tenant in full unless the landlord actually paid for any services, such as a credit check, in reviewing the tenant's application. So if the landlord, like let's say the landlord got 30 applications for the rental, because we all know, there just aren't that many rentals that are vacant these days. So let's say the landlord gets 30 applications for the place and yours is number 29. It may be that the landlord rents the place to the applicant who was number 5 and charged application fees to all 30 of the applicants, but only ran the credit check or did any kind of background check on the first 5 applications. Well, that means the remaining 25 applicants may be entitled to a refund of whatever amount they paid as an application fee. And those fees add up, right? Sometimes they're $30 per adult, sometimes even $50 or $75 per adult. So if you are a tenant in that situation, you can contact the landlords that you applied to that you didn't get the place from and ask them whether they ran any kind of background check on your application. And if they didn't, you can ask for your application fee to be refunded. Then the second law it concerns rent paying fees. So this new law applies to tenants who are charged a fee per month depending on the way they pay the rent. So, like for instance, if the landlord has asked that the tenant go to Walmart and use a service there at Walmart to pay the fee, Walmart, the service there, will charge the tenant $4 every time they use that service when they pay their rent. So if they always use a service once a month, they're going to end up paying $4 every single month to pay their rent. And as of June 9th of this year, Montana law bans a landlord from charging a fee to a tenant based on their type of payment, based on the method of payment for their rent, except if the landlord was charged a fee by their bank to receive the payment. So if a tenant pays, for instance, by a direct deposit from their bank account to the landlord's bank account, and the landlord's bank charges the landlord a service fee, let's say $4 a month for receiving that payment, then the landlord can charge that fee to the tenant, that $4 fee. But if it's not a bank fee charged to the landlord, then this new law says that landlords cannot charge those fees to tenants. Okay, then what is the law in Montana concerning rent increases? Montana has no cap on how much a landlord can raise the rent. Some states do, Montana does not. So that means a tenant may have been renting a place for, let's say, 5 years, and their rent has always been $1,000 a month. And maybe the landlord sells the place to a new owner, and that owner issues a notice saying they're going to raise the rents to $2,000 a month. The tenant does not have any option under Montana law to claim that rent increase, even though it's doubling the amount of the rent. There's no law that says that rent increase is illegal. The general rule in Montana is that a landlord must give at least 30 days advance notice of any rent increase. If you're a month-to-month renter, you're entitled to 30 days notice. If you're under the term of a lease, say you've got a 12-month lease, then the landlord can raise the rent at the end of the lease and must give the 30 days notice in advance before the lease expires to let you know that, hey, when your lease expires, your rent's going to go up to a higher amount. And sometimes the party's lease agreement will have a different provision as far as how many days advance notice has to be given if the rent is going to be increased. And keep in mind that contract signed by the tenant and the landlord is an agreement that's enforceable by both. So if the lease says something different, you may need to abide by the term that's in the actual lease. not just going by the 30 days notice for the advance warning of any rent increase. Okay, so what about a security deposit? And most of us know a security deposit is an amount of money paid by a tenant when they first move into a rental. And that money is held by the landlord until the tenant moves out to make sure, or so that the landlord can use that money to apply to any rent owed when the tenant moves out, or any damage caused by the tenant while they live there. Um, so the law that applies to security deposit says that when a tenant moves out, the landlord must inspect the unit after the move out. And if the landlord believes that there's additional cleaning that needs to be done, the landlord must give the tenant written notice of what needs to be cleaned. And then after receiving that notice, the tenant has 24 hours to complete that cleaning, or the landlord can withhold the cleaning costs from their deposit. But if the landlord already has filed a lawsuit against the tenant and has a claim pending in court for damages against the tenant, then the landlord doesn't have to give the 24-hour notice for the tenant to do the additional cleaning, because the intention is that if the lawsuit is already pending in court, then the law will just allow the judge to figure out what deductions are reasonable from the security deposit, and the tenant will not get the opportunity to go back and complete additional cleaning because the judge is going to sort it all out in the hearing. Okay, the law also says that the landlord must return the full security deposit to the tenant within 10 days after a tenant moves out if there are no deductions from the security deposit. So there's no cleaning needed, the rent's all been paid, there's no damage to the premises, and there's no unpaid utilities. If there are any of those things, then the landlord can take up to 30 days after the tenant moves out to refund the tenant's security deposit, and to include, if the landlord is withholding any money from the security deposit, the landlord has to provide a list of the deductions from the security deposit for things like damage or rent owed or late fees owed, utilities, whatever the charges are. And again, this also, the requirement that the landlord refund the money within 30 days also does not apply in the circumstance where the landlord has already filed a lawsuit against the tenant in court and has a pending court claim for damages against the tenant. Because again, the thought is just let the judge sort out who owes how much money. Okay. So that is the end of the outline. I wanted to let folks know that if you need free legal help with a matter resolving or about landlord-tenant relationships or evictions, you can apply to Montana Legal Services Association, the organization that I work for. We have a toll-free number, and you can also apply online. We also have a website of legal information, and I provide the link to that website here. It's called montanalawhelp.org. And this is a website that has information on all kinds of legal issues, not just housing issues. So be sure to check that out. It's free information. It's up 24/7, and hopefully you'll be able to find answers to your questions, whether you're a landlord or a tenant.
And we have about 10 minutes for questions. So while Amy provides any additional general information, if people want to pop something into the chat, we can pick up a few more questions before we call it an evening.
All right, while we're waiting to see if anybody has questions, I will go ahead and pull up the security deposit law, just so folks are familiar with what the laws in Montana look like, and anybody can look up the law and read the law for yourself. You'll see this is the full uh, assortment of Montana laws. You'll see we have 90 titles in Montana of different laws. And this was updated, this list was updated on December 18th of 2024. It does not include the most recent updates that happened in the legislative session that ended this spring, but those will be coming out soon. But if we go to Title 70, which we see as the property code, we can open that so you can get a feel for what this looks like. We talked about the Landlord and Tenant Act of 1977. That's the one that applies to apartments and rentals. That act is Chapter 24. The Security Deposit Act is Chapter 25. And then the Mobile Home Lot Rental Act is Chapter 33. So I'm going to pull up the Security Deposit Act just because it's the shortest. And I just think it's important for all of us to know how to access Montana laws. So that's why I wanted to show you, it's really not that hard to pull up the laws that apply. So if we go to the rights and duties section of the Security Deposit Act, I'll pull up this section. So this is the section that says the landlord within 30 days after the termination of a tenancy has to provide the departing tenant with a list of the deductions from the security deposit. So it's all laid out pretty clearly in Montana law. So if you ever have questions about what your rights are and those questions are not answered by Montana Law Help or other online resources, I encourage everybody to go straight to the law and look it up for yourself, because often you will find the answer to your questions in the statutes themselves.
We do have one question in the chat, which is, what are the most common issues you see that result in eviction?
Um, well, that it varies a lot, but one pretty common one is non-payment of rent. Tenants get behind on the rent for whatever reason, and they face eviction for that reason. That's why I encourage folks who are behind on the rent to call 211 to try to access help to get the rent paid. Because if a tenant is behind on the rent, there's often not much of a remedy there for the tenant, because the tenants are obligated to pay rent 100%. There's no question about that. So if they have not met their obligation, the landlord may have solid grounds to evict them. Other grounds for eviction, like one that I've seen recently, is a tenant who wasn't keeping their place tidy enough. The landlord thought it was in unsafe condition because fire exits were blocked, the windows and the doorways were blocked by all of the belongings of the tenant. So, tenants who get a notice from their landlord saying, hey, your place needs some attention. You need to clear the fire exits and that kind of thing. Tenants should be sure to do that and respond to that notice within the time period given in the notice so that they won't face eviction. So those things are common. Having unauthorized people living there is pretty common. All of us are entitled to have guests in our rentals, but your guests cannot stay longer than the landlord's rules allow. So they can't stay overnight longer than, usually it's 7 days or 15 days in a 6-month period. But usually it's set out in the lease or the house rules. And if the tenant is allowing people to stay longer than that, they may face eviction because of that.
We have a question in the chat about religious discrimination, and I'm not quite sure what direction we're taking with that, because I know it's a broad question, and perhaps the person will add a little clarification to their question. But are there any? I guess I would ask, the way I would phrase it is, are there any special laws regarding religious discrimination, one way or the other, that you've seen issues arise in Montana?
Um, we don't see this come up. I haven't seen it come up very often. But for instance, an example would be that if someone is Muslim, for example, a landlord who is covered by the fair housing laws cannot refuse to rent to them solely because they're Muslim. Um, that's treating them differently because of their religion. And the same thing goes to other kinds of examples. So, like if your religious practice, for example, is that you do smudging, which means burning sage, um, there may be a claim of religious discrimination there if your landlord doesn't allow you to burn sage. Now, landlords can have rules at their premises that are intended to keep the premises safe. So, smudging, if by lighting the sage, there's a danger to the premises that it could cause damage to the premises, then the landlord may be justified in um, denying that kind of accommodation for somebody's religious practice. But I'm not familiar with that case law exactly, so I shouldn't have even used that as an example because there are always gray areas in the law. But religious discrimination just means that you cannot be treated differently because of your religion, basically. We should all be treated the same, whether it's based on religion, disability, whether we're married or not, whether we have kids or not. The fair housing laws protect all of us, saying that we should be treated equally under the law.
We have 2 minutes left, and we've got some thank yous in the chat. Anything further to wrap up this evening's program, Amy? Anything else you think folks should know?
I just again want to encourage everybody communicate with each other because honestly, everybody's interests are served by reaching a resolution of whatever the disagreement is without having to go to court. Everybody is better served by that outcome rather than putting it all out for the judge to decide and then hoping for the best. So I hope this was helpful to everybody and I look forward to attending the next session, which is next week, I believe, and then the Citizens Law School is over. So thank you, Brenda, and the State Bar of Montana for hosting these sessions.
Absolutely. And yes, we have one more program on November 19th. We will have Constance Van Clee, and who will be discussing Montana constitutional law. So just want to thank everyone for attending, and I'm seeing more thank yous in the chat, and thank all of you for being with us, and hopefully we'll see some of you next week.
Thanks, everybody.